these are the three conclusions that I'd like you to have in mind by the time we arrive at the end of the talk. Number one, crypto assets are well on the way to being recognized as a new category of personal property. Secondly, traditional causes of action and remedies apply to crypto assets. For example, they can be the subject of constructive trusts, claims for restitution, and remedies such as injunctive relief. And thirdly, crypto assets can be traced through crypto exchanges applying established equitable principles. And the theme underpinning these three conclusions is that the court are in a process of adapting existing legal principles to a new context, meaning that your existing knowledge and skills is all that you need to have confidence in this area. What is money? What is credit? Or what is a check? They're all things that are not particularly easy to describe in the abstract, but we know them when we see them. And so we are talking about things like Bitcoin, Ethereum, and Tether. Or to put it another way, they're a type of digital currency which is distinguished from other currency insofar as there is no third-party intermediary to a transaction. In other words, there are no banks or other lending institutions. So the Bitcoin white paper was published in 2008. Crypto assets represent trillions of dollars in the global economy. They're increasingly a class of asset for corporate investors. Most notably in 2021, Tesla invested $1.5 billion US in crypto. And research conducted by the FCA in this country indicates that since 2020, personal ownership of crypto has increased from about 4% to about 12%. So, in the business and property courts generally, I expect that it is likely to crop up in these areas. Wills, probate, and trusts. Can you, for example, bequeath crypto, or can it be the subject of a trust? Insolvency. Does crypto fall within the definition of an asset for the purposes of disposal? Commercial fraud or ransomware blackmail, because I'm afraid to say that crypto is the preferred currency of the blackmailer. And contracts, including obligations relating to crypto assets. So that first headline, crypto assets as personal property. So when we speak of personal property, what we really mean is anything that is not land. And it's been divided traditionally into stuff that you can touch, like a car, and non-stuff that you cannot touch, like a debt, which is described as a chosen action. And that dictum from Colonial Bank and Winnie is the sort of opening sentence of lots of textbook chapters. You can have personal property either in possession, that's stuff, or in action, and the law knows no tertium quid between the two. Now, crypto, meaning secret, was imagined explicitly as existing outside of that dichotomy, and indeed, I think it was believed that it could engineer out of existence the need either for interpersonal trust or laws. And this is a part of what the Bitcoin white paper said, that transactions that are computationally impractical to reverse would protect sellers from fraud. Routine escrow mechanisms could easily be implemented to protect buyers. And in this paper, we propose a solution to the double spending problem using a peer-to-peer distributed timestamp server to generate computational proof of the chronological order of things. So there we are. Looked at from the classic conception of property in English law, crypto is not property. Looked at from the aspiration or intention of the author of the Bitcoin white paper. They're really saying we actually don't want to be in your legal system. We don't need to be because this is a cleverer idea than that. In fact, in English law, crypto assets, as I indicated, are well on the way to being accepted as property. And this, in what I suggest, is best understood as a product of judicial policy. And so this was the Master of the Rolls in 2019, speaking extrajudicially. And this has really been the policy of the English judiciary since the foundation of the commercial court in the 19th century. The first point to make is that the market, nationally and internationally, is treating crypto assets with various characteristics as economic assets. Of course, the law can decline to follow the market, but it does so at its peril. So this, I would suggest, is the easiest way to understand the approach of the courts in our country, which is just to say that it exists factually, it is economically important, and we are not going to turn our faces against it on the basis of something that was said obiter dicta in the 19th century. And that translated into judicial decision-making, in this case of AA and persons unknown and Bitfinex in 2019. This was a case which arose from a ransomware attack. The hackers had demanded as the price of decryption the transfer of Bitcoin to the value of 1.2 million Canadian dollars. The claimant, AA, was in fact the victim's insurer. They authorised the payment, but immediately took steps to trace and retrieve the funds. They engaged an organisation called Chainalysis Inc. To trace the funds into the international exchange. And there were a number of interesting preliminary points. Firstly, the claimants were permitted to seek injunctive relief on an interim and ex parte basis and with anonymity. And essentially, the blackmail jurisprudence was transposed over into this area as a justification for anonymity. They did pursue a waiver injunction and a Norwich Pharmacal order on the facts. Those applications were withdrawn by counsel, but the court didn't indicate that it was wrong in principle to seek them. And the principal issue for determination, albeit that this was an interim decision, was whether Bitcoin was property. That was the first line of defense of the exchange. It's not property, therefore there's nothing to argue about. And the answer to the question of is Bitcoin property was essentially yes. And the route to that conclusion was to fall back on very familiar territory, National Provincial Bank and Ainsworth, so Lord Wilberforce in the House of Lords in 1965. There are 4 characteristics of property. It's got to be definable, identifiable by others, capable of assumption by a third party, and having some degree of permanence. Subsequently, the Law Commission was invited and in fact has reported on this topic. There was rivers of academic ink spilt on it, but what they essentially said was AA is the correct approach, the law is the test from Ainsworth, And the best thing to do is for the legislature to get out of the way and allow the courts continue to adapt to the issue. So this is the draft bill currently before the House of Lords. I think you can expect it to become law in the not too distant future, which just says that a thing is not prevented from being a thing because it is not a thing in possession or a thing in action. So it's abolishing that dictum that were looked at before from the 19th century. So that's the headline number one. Headline number two is which lever to pull. This is a case study, I suppose. It's the first case involving crypto that has gone to trial in the High Court. Mr. DeLawyer was the claimant, and the first defendant, they were people unknown who described themselves as TD Finnan. They were fraudsters, probably passing themselves off as TD Ameritrade. And they succeeded in inducing Mr. DeLawyer to transfer $2.5 million in Bitcoin to them. So from a practical point of view, they were sued, but obviously a Pyrrhic exercise. You can't find them. You can't get any money out of them. And so the people that were brought in, D2, D3, D4, D5, D6, these were the exchanges where the Bitcoin was traced to through a series of what were described as hops. And all of these bottom ones, they either settled, they were dealt with by summary judgment or strikeout. And the trial just involved D6, BitCub online. And they had a customer down here called Miss Langpan. So BitCub are based in Thailand, and Miss Langpan had opened an account with them in Thailand, declaring that she had a monthly income of 15 to 30,000 Thai baht per month. And within days, her bank account had received and then had debited the equivalent of 13.5 million Thai baht, or about 400,000 US dollars. And again, Ms. Langpan is there as a defendant to the proceedings, but no point in having her there really from a practical point of view because there are no assets. And so the claim focused really on BitCub with its deep pockets. And the court identified three general issues. It identified loads and loads of issues, but three general issues. Number one is tether property. What courses of action against BitCub did Mr. DeLawyer have? And can you, in law, trace the assets? So Tether is a variant on Bitcoin. And without being a tech bro and just being a BPC lawyer, it is enough to know that it is a bit like Bitcoin, but instead of being a floating asset, its value is literally tethered to the US dollar. So Tether claim that they've got a pool of hard currency, and on that basis, they're able to guarantee to anyone that holds the currency that they'll be paid out the value of the US dollar from time to time. So not surprisingly, after about 70 paragraphs of analysis, AA was followed. Tether is property in English law as things stand. Bitcoin is. And I shall be quite surprised to read any judgment now which finds that a cryptocurrency is not property. Now, Mr. DeLawyer, the claimant's basic contention was this. BitCub had thumbed its nose at any rules or best practice regarding anti-money laundering in Thailand, and that it could not have failed to notice that this person who just had a very normal income had no legitimate way of getting £400,000 paid into our account, and they should have put a stop on it. And in evidence, that was pretty much established. But that left over the question of what the appropriate cause of action was. And the judge, after requiring the parties to do a certain amount of repleading, settled on at least two valid causes of action. Firstly, there was capable of being a constructive trust at BitCub. That was because the original transaction with TD Finnan was a fraud and of no effect, or because a constructive trust would arise on the date of rescission. And the court also applied, again, familiar territory, bank, financier and Battersea Limited, to the effect that there could be a claim for unjust enrichment or restitution. So there you go. These are examples of very familiar lines of authority being applied in a new context. The court then had the further problem of analysing if it was legally permissible trace the assets. So what happens, apparently, is that these funds are transferred to BitClub. There's then a process called sweeping, whereby the individual assets are swept into a common pool, which are the property of BitCub, and from the sweep, they're transferred into a hot wallet, which is the property of the customer. And what BitCub was saying in very general terms is, how could you say that any of the money that came out at the other end was the same money that had been taken in the fraud from Mr. DeLawyer? And the court distinguished the correct approaches. First of all, it recapped that at common law, you can follow an asset, a tangible asset, from one hand to the other, but not through a mixed fund. And they said that so far as your unjust enrichment claim is concerned, that claim won't run. As it happens, it's only a first instance decision. That does cut against the idea underpinning the recognition of crypto as property, that it doesn't matter what you call it, you've just got to deal with it as property. So whether this distinction between common law and equity lasts remains to be seen. On the face of it, from a purely practical point of view, there doesn't seem to be a huge justification for it. However, the court went on to hold that in equity you can, and it recounted all of the traditional equitable means of following an asset. So first in, first out, pari passu, or the rolling charge or North American method are all permissible methodologies that can be applied in this context. But as so often, the claim fell down on the facts. So coming back to those blockchain analysts who'd been employed to follow the funds, they were really investigators, and what they certainly were not were forensic accountants. And so this blockchain analyst who gave evidence on behalf of the claimant in the High Court, in his report, he'd said that he'd used the first in, first out method. And the problem with his evidence was that it was established that he hadn't precisely used that method. What he'd actually done is he'd run a program on a piece of software that he'd been trained in. But where it fell down is that he'd said it was FIFO and it wasn't. It wouldn't have mattered whether he'd done FIFO or pari passu or the rolling charge. The point was that he hadn't done what he'd said he'd done, and the court therefore held that Mr. DeLawyer had not proved his case on the facts. So I suppose 2 points to take away there. If you ever do deal with this, you might want to instruct a blockchain analyst and a forensic accountant to work side by side. It may be that the forensic accountants in due course swallow up this expertise into their practice. But most importantly, tremendously complex case, loads of law thrown into it. Where was it won and lost in the end? It was really won and lost in the end on proving as a fact that it was your money in her pocket. So, my conclusions, new tools or old. Firstly, crypto is personal property. The conclusions are the policy is that the law will follow the market reality. And the law is the Ainsworth test. That is to say whether a particular asset on a case-by-case basis is definable, identifiable, capable of assumption by another, and permanence. The causes of action that can be applied in this context are not by any means closed, but we've seen that crypto can be the subject of a constructive trust. It could, in principle, be the subject of a claim in restitution. And the current state of the law on tracing appears to be, and we've only got one first instance decision at the moment, is that tracing through a mixed fund, which an exchange typically will be, can be done for equitable causes of action, but do get your experts right. And so looking at those conclusions, what I would suggest is that there's no special legal expertise required at all to deal with this subject matter. And that all that is required is the willingness to apply first principles in a new context. And so I think that you all ought to be confident in dealing with your first or second or third cases involving crypto assets if and when they come along.